Buns? Yeah, I don't know what. Danny, Berlin. No problem. Only so.
No problem. Oh, that's
Yo. Oh, that's. Yes.
I agree.
There's no clicking. The clicker, right? Like the presentation. If there's no presentation clicker, I think you gotta like on my level.
We don't have it 100%.
Does it work here? No. No, it doesn't.
Here.
Oh, okay. Thanks.
Got it better.
We can set this one. Do you need the cap at all?
I think if I want to reverse it,
Probably
it might
not.
rub against it.
I don't think it's too live. Sure, maybe it's better this way.
Is it on? Do you want to test it? Turn the microphone on.
Yeah, it's just like reading talking to the screen. No, he only wants it to show them, and then we have
And talking to it.
oh, over this. Yo, I can almost
Okay?
actually, can you test the message in like contact?
Professor.
Is that all you did? Just work.
No.
No, just talk loud.
Yeah, just talk loud and then.
Alright. See that. We'll multiply. If I have 5 more minutes. Okay, you just use like my. Okay. Yeah. So what do I do? Yeah, just use my arrow keys. Oh, this is not cooking. So yeah, you just. Okay, sounds good. Yeah, no, I just essentially. Oh. No, it's not. Sorry.
So why can't you use that computer?
I don't know.
Yeah, why can't you?
Can we just use this computer? Because it doesn't have my software.
Also, you have to live stream. You're live streaming that right now.
With the software?
You're live streaming what's on your screen.
Yeah. Yeah.
Oh, I see. Yeah.
Yeah, it's because that computer doesn't have
Yeah.
software.
Like otherwise, we just be live streaming it for you. Or you have a video camera.
beyond that. And like, yeah, they're just kind of hard to navigate, you know? Like, it's just, it's tedious and it's hard to understand what it means, right? You really find yourself in a reader. Yeah, I was like, it'll probably just be me like I mean, the fact that it's really takes a lot. Yeah, I like that one. It's just a lot of shit to remember, but I think we'd rather do a lot of things. Well, I just literally like
Why is there Starbucks in our bag? That's insane. Yeah. You walked the whole thing and they were out like $500.
yeah.
Accidentally dropped it in my backpack. I'm finding it.
Which I honestly don't like. I don't like. I don't think it.
Hey guys, I'm gonna start around 5 minutes later, just so that people can come in and settle down. I'll start at 6:05.
Find a way on other terms. Sure, yeah. Want to listen to it. Yeah, surprisingly, I was a little worried. She came, dude, it was like she came right up to me and fixed that. I freaked out. I never do this because I knew I wasn't going to get that kind of content. It was just
Hi, everyone. Can I have your attention, please? So, first of all, welcome to Comm 393 Commercial Law CMP review session. When are you guys midterms? Thursday. Wow. Okay. Good luck. And so today, the review session will be hosted by Roy Huang, our very capable and intelligent instructor for Comm 393. Just to let you know a little bit about how this session is going to run. It's going to take approximately 2 hours, but about 1 hour in, there will be 5 minutes where I would ask all of you to fill out a feedback form for this review session. Feedback is very important for CMP because we need to know how we should improve and what we can do better next time. And as a reward for filling out the feedback form, all of you who do fill it out will be entered into a raffle draw to win a $20 Starbucks gift card. And the winner will be picked right at the end of the session. And if you stay here till the end, you can receive the gift card right away. So that's to let you know that about 1 hour in, there will be a 5-minute break for you to fill out the feedback. I'm off to Roy.
Thanks, Mr. All right. So, how's everyone feeling today? Good. Good. All right. So, a little bit about myself, I guess. Who am I? Not sure everyone's here to see this, but I'm currently a year 3 accounting and operations logistics student. I'm a part of the supply chain management club here at Sauder, and I'm also a mentee this year for the EMP program. I'm a part of Golden Key International Honor Society. Also, I went on a China trip just this past May. I'm sure you guys are asleep by now, so I should probably move on, right? Okay. So I think, first of all, I want to go through the general advice for you because this is probably the most important part of today. That is knowing how to answer the question on your midterm. Right, so I think your prof probably went over this for you already. When you answer a problem on the exam, you're going to focus on, first of all, identifying the legal issue. We're looking at what's the legal problem that you're being asked to solve. And then we go to move on to the law principle, where we can define what the law is, we give a clear statement of the legal principle, and we state the source. For example, it could be a case that we studied. And then we're going to go into the application part. How does the law apply specifically in this scenario? And then from there, we go on to the conclusion, which is the decision that we're going to make. Who's going to likely win the case? Who's going to be more successful in the claim? Just a quick agenda. We're going to do 4 things today. We're going to go through a quick walkthrough of the related cases to each topic. And then we're going to thoroughly analyze each review package problem. I'm sure you guys probably already seen this if you went onto the Facebook site. Yeah. You can open the review package document on the Facebook event page if you have an electronic device, or if you already have a printed copy, that's perfect. We can go through it together, and then if you don't have any of them, we'll go through the slides. Just follow the slides. We'll also determine how to answer each problem using the method called the I like method that we talked about here. And then from there, we're going to have a short break in between. So it's not too troubling to stay 2.5 hours. Oops. Over here. Agenda. All right. So I decided to list out many topics that I think are going to be most likely tested on the exam. And then in miscellaneous topics, we're going to cover more of the memorization part of the course, where there probably won't be a lot of case-like problems in that, and memorization is probably a little more important than those cases. All right. So does everyone already have this or have access to this? If you don't, just follow the slides. All right? We're not going to do a lot of writing in this review session because I believe I'm going to post you a solution package, which I already made. It will be uploaded to the Facebook group, and I will let them know how they decide to give it to you. But I'll make sure that you get this at the end of the day so that you can use it to refer back to the problems. All right. So the first question in the package that I decided to put first is the Constitution Act and Charter of Rights and Freedoms. I'll go over this pretty fast. I'm going to read the problem, and then we're going to work out a solution together. So John Anderson is a university student who always wanted to work in public accounting. Consequently, he applied for a tax position in KXYZ. Has no relation with any of the public firms. A public accounting firm. Among over 2,000 applicants, John was selected for an interview based on his remarkable GPA and past experiences. However, despite meeting all of the qualifications for the job, John was not hired for the position after his interview. So he's wondering, okay, why? So John's friend who works at KXYZ later found out, okay, hiring manager disclosed John's application only because John has a physical disability and could only work in a wheelchair. John's friend advised him to sue KXYZ under the Charter of Rights and Freedoms. Is John likely to succeed? When we go about approaching this problem, we try and settle with the ILAC method that we talked about. So what's the issue here? Right? The issue here is whether can John sue KXYZ under the Charter of Rights and Freedoms. When you read the question, you say, okay, well, that's what the question's asking. How can I relate it to something that we learned? Charter of Rights and Freedoms is what we learned in class. From there, you have to go and move on to the law piece. The law piece is, you mention something, a law principle, for example, but you have to define it. Nobody's going to know what the Charter of Rights and Freedoms is if you don't talk about it in your answer. And that's going to be a part of your answer that's going to earn you quite a lot of points. So here, we want to clearly define what are the requirements for the Charter of Rights and Freedoms. The Charter of Rights and Freedoms only applies to government and prevents the government from creating legislation which would infringe upon any of the rights protected in the Charter unless the infringement can be demonstrably justified in a free and democratic society under Section 1 of the Charter. So this part, you're going to have to memorize it. Memorize, once you see the Charter of Rights and Freedoms, plug it in. That's all you need to do. Get it in your head and think about it. Okay, when I go about answering it, I need to explain the Charter of Rights and Freedoms. From there, once you have the law settled out in your answer, that's where you can apply it. So in this case, KXYZ is a public firm. It's not a government agency. So therefore, the Charter would not apply. I would like to highlight that when you write it would not apply, what's the case that you immediately think about? Lippmann versus Canada. We talked about it in class, right? Lippmann was against the Canadian forces. The Canadian forces didn't let him into a position because he was Jewish, right? But in that case, it was very similar. So where you lay out your answer, you will write, unlike Lippmann versus Canada, where the Canadian forces is indeed a government agency. From there, we conclude John is unlikely to succeed. Why? Because not in the Charter of Rights and Freedoms, it's not protecting non-government agencies, and can consider to bring its claim under the Human Rights Code. How was the first answer? Was it horrible, or was it not too bad? How do people feel? All right. Can we move on? All right.
You know, Bob, I actually take that case. Get a picture.
Okay. All right. Moving on to intent, offer, writing, and acceptance. This is actually a pretty major part of the program we've probably learned so far. I want you to pay specific attention to this. And I think I'm going to have a little bit more questions here for you to practice. There's 3 parts. So first part, I'm going to say the question. So on October 6, 2015, Alejandro sent a letter from Vancouver, BC, offering to sell his Comm 393 notes. I wonder how much that's actually worth. For $50 to Rosa, who's currently on staying at Toronto, Ontario. After Rosa received a letter from Alejandro on October 8, 2015, she sent the letter back to Alejandro on the same day. In part A, we're going to assume that Rosa accepted the offer in her letter. Which law would apply to this contract? The law of BC or the law of Ontario? Sometimes you see this question, you might get an immediate answer. Okay, well, it's probably the law of BC or it's probably the law of Ontario. A lot of times, that's just really not enough when you're answering the question. When you're answering the question, you always follow the ILAC method as we discussed. So here, we want to look at the ILAC method. What's the issue? The issue here is in which jurisdiction has the closest connection to the contract. You want to find which jurisdiction connects or relates to this contract. So then we look at the law. Right? Usually, where the contract is made will be the determining factor. Where the contract is made. According to the postal acceptance rule, when it is reasonable to accept by mail, acceptance is effective when sent. When you lay out the law, you lay out, okay, what's postal acceptance rule? Because we're talking about how does it relate to this case? Okay, so in this case, it was reasonable to accept by mail because the offer had been by mail. It wasn't laid out on the contract, on the term of the contract, but we can infer that because it's by mail, then it's also effective to respond by mail. Therefore, effective consent. How do we apply it? In this case, it was reasonable to accept by mail because the offer by mail. Acceptance would be effective in Ontario, where the acceptance was mail. So Rosa sent in the acceptance letter into her mailbox. In Ontario, Luke accepted contract form. Conclusion: contract was therefore made in Ontario, and Ontario law would likely apply. And again, now we think about the case, right? Like Letter versus Microsoft, jurisdiction was an explicit term in the contract. Here, it's not mentioned. It's okay to accept by mail. And to conclude that, where it's accepted, Ontario. Okay. Moving on to part B. Did everyone feel that was all right? Understood? Okay. Okay, great. Part B. Assume that Rosa accepted the offer in the letter. Now we want to assess Rosa's legal rights if Alejandro already sold his notes to another buyer and did not send his revocation letter to Rosa until October 10th. Okay, well, he's getting himself in pretty big trouble here. How do we answer that question, right? We, again, use a similar method. The issue here is whether a contract between Rosa and Alejandro before the offer was revoked. So in your issue, you identify what's the problem. But from there, revocation occurs when an offer is withdrawn by the offeror before the offeree accepts the offer. Revocation occurs when received. Offer and acceptance are main elements of a contract, and when present, a contract has usually been formed. According to the postal acceptance rule, when it is reasonable to accept by mail, acceptance is effective when sent. It is, in this case, it is reasonable to accept by mail if the offer was by mail or if the offer explicitly stated to accept by mail. Why am I going through this again? Because when you're answering this part, it again relates to postal acceptance rule. When you write postal acceptance rule, make sure to define it. When you write revocation, make sure to define it. If you don't define it, you're not getting that mark. Alright, so going to the application piece. Right? In this case, Alejandro made Rosa an offer by mail on October 6th, and Rosa accepted on October 8th when the acceptance was mailed. We got that already, right? Now from there, as it was reasonable to accept by mail, a contract was formed on October 8th, before the revocation letter was sent on October 10th. When we conclude, we say, well, therefore, Rosa can sue Alejandro for damages. You can see it's a very simple question, but the answer is actually pretty long to be inclusive. On the exam day, when you get this question, you want to think fast and you want to write fast, because your answer should include all of these parts. Was everyone okay with that? Got a chance to get it down? Yeah? Getting understood? Again, I will post the solutions later on, so don't worry if you don't have it. Um, and if you have any questions, feel free to raise your hand or ask me or something that you don't understand, or ask me later even in the Q&A period. So we're going into part C of this question. Right, now, assume that Rosa did not accept the offer in her letter, and instead he asked Alejandro to sell his notes for $40. When Alejandro received this letter, he responded back to Rosa on October 12th, a couple days later, refusing to sell his notes for $40, and informed Rosa that due to height of that, if it's my notes, I guess there's height of that. But okay, anyways, he will now sell it for $80. Rosa now regrets not accepting Alejandro's original offer at $50. Would she be able to sue Alejandro to sell her notes, to sell his notes to her at $50? No. Okay. But how do we go about answering it? Again, we look at the issue and the law principle and the application piece, and then to conclude. Right. So, what's the issue here? Whether Rosa's request can be considered as a counteroffer. Was that a counteroffer? Was that the $40 counteroffer that results in termination of the original offer? So when we realize, okay, well, it's about counteroffer, that's when we go into the law section. The law section says, well, a counteroffer occurs when the offeree, that's the person being offered the offer, fails to accept the offer from the offerer, and subsequently becomes the offerer by making a new offer. A counteroffer terminates the original offer. That's the law principle that you learned in your class, in your law camp. That's why, if it applies to this case, the counteroffer part, then have it down, have it in your answer. There we go on to application. Right. So in this case, Alejandro made Rosa an offer on October 6th. Rosa didn't accept the offer, failed to accept the offer in her letter on October 8th, and counteroffered in her letter. Unlike in Montaigne versus Schroeder, what happened in that case? Anyone remember? Montaigne versus Schroeder? Right? It was a mere inquiry. It wasn't judged as it being a counteroffer. So here it is a counteroffer because Rosa became the new offerer, and the consideration is $40 for the notes. And then, as neither parties accepted any of the offers they made to each other, a contract really never formed. Therefore, we can go about concluding that Rosa cannot sue Alejandro for what? For specific performance. Any questions on this? Are you guys feeling good? Good? Don't worry too much about jogging them down again. These will be posted, the solutions will be posted. If you have time, make sure to check back. Sell all notes. Take my money. Alright. Moving on to consideration and promissory estoppel. I have some problems trying to name things, so it's like I came up with them on the spot. But anyways, Kitchener lawnmowers, KLM. I think I got that from there, but anyways. on to Natasha's home. KLM and Natasha signed a contract setting the price, lump sum fee of $100. Contract did not mention the names of the grass. Didn't mention any of that. While mowing the lawn, KLM was like, ugh, that grass is way too thick and long. There's no way I can do that, right? There's no way. So KLM goes to Natasha saying, okay, well, I can't complete the contract unless you give me $80 so I get a piece of equipment. Right? I need to get a piece of equipment to mow your lawn. Now the first part, I guess, does Natasha have a legal obligation to pay the $80 that KLM demands? You guys think no? Right. So here again, we're gonna go into how to answer this problem. Perhaps you see it, you're like, no. Think in your head, okay, why no? That's our issue. The issue here is we're trying to add to an existing legal duty. They already have a contract made, right? How are we adding to an existing legal duty? And what is required? Well, a new bargain always requires new consideration. A new bargain requires new consideration on the part of each party. Consideration is what a party gives up or promises to exchange in return for the promise of the other party. Consideration is the part where I also think, make sure you define consideration. Don't forget to define consideration. Because that's going to be a big part of your answer if you're going to write it. Application, right? How does this apply to this case? What did we learn? Okay, well, in this case, a KLF did not promise to do anything extra in return for Natasha's extra 80. Before they got the contract already settled at 100. You're trying to charge Natasha for an extra 80. You're not supposed to do that. You can't do that. So in conclusion, there's really therefore no consideration, and Natasha's not bound to pay the $80. Any questions on this? All good? There's a second part to this question. On the exam, you're going to have questions that's going to have multiple parts. So make sure to, I know it exactly better. There's more parts, so you don't have to do the case points. Ignore the top part. Now part B, we assume that Natasha agreed to pay KLM $80 to buy the equipment, payable at completion. KLM went and purchased this equipment, completed the work. When the work was completed, Natasha paid $100, but refused to pay the additional $80. Here, explain promissory estoppel. Would it help KLM in this case? What do you guys think? Yes. No? So kind of a mix right now, right? You know what? I'm going to tell you this. The conclusion really doesn't matter. What really matters is that you define the law terms, you give a clear explanation, and you tell them how you reach your answer, right? You have to kind of reason it. The law is not always that black and white, but you just have to reason it. Here, we want to look at the issue. And the issue here is whether the doctrine of promissory estoppel would apply. That was mentioned in the question. Would it apply? Now we look at the law. The doctrine of promissory estoppel says, well, that if the party creates an impression that it will not rely on strict legal rights, and that the other party relies on that promise, this party cannot later take the other party by surprise. The doctrine of promissory estoppel can only be used as a defense, and when there is already a contract in place. My thoughts on this question when I first saw it was pretty much just like yours. I was saying it probably should help. But then the application of this case is when we think about who's going to sue and who's going to use it as a defense, it's a little bit different. Here in this case, by agreeing to pay the $80, Natasha has created an impression that she will not rely on this opioid contract. We got that. However, in suing her for the $80, KLM would be trying to fund its claim in estoppel. Unlike in Tulsa Heaters versus Accrued and Duke's Cookies versus CBC-AMS, Tulsa Heaters versus Accrued was Accrued using it. Tulsa Heaters was defending, and then Duke's Cookies versus UBC was Duke Cookies using it as a defense, but where the doctrine can only be used as a defense, cannot be used to fund a claim. It cannot be used as a sword. Therefore, you can conclude it will not help KLM. Again, I want to say that the conclusion is not what matters the most. On a question like this, your answer might be it would help KLM. This was actually a very similar question on my midterm, and I got this wrong. But I like to say it's not the conclusion that matters the most. It's saying what the doctrine of promissory estoppel is, and saying all the strict little guidelines to what is doctrine of promissory estoppel, lay it out, and apply it to this case. Yes? KLM is trying to get the extra $80 from the contract. Doing that, KLM would have to start a lawsuit, right, and use it as an attack to get the money out of the contract. Can you do that? No, not really. Doctrine of promissory estoppel can only be used as a defense. Anyone else have questions? This was a little bit tricky, right? Alright. So, moving right along. Again, your name here. When I made this question, I saw that Mary had a little laugh. Mary is going on a field trip to Science World. It's a grade 5 class. Third lab elementary. Third lab elementary. So, I don't know. Well, I like that game. Okay, so, gone on field trip. 2 weeks before the trip, Third lab elementary asked Mary to sign a form where she agrees to pay a non-refundable $10 fee for the field trip. Mary had to sign a form. She signed it, paid the $10 fee the following day. Assume that it is the day before the trip. Mary caught a cold. I'm not feeling well. No longer wants to attend. Is she entitled to reclaim the $10 she paid? When you think about this question, okay, Mary, grade 5 class. That implies she must be infant, exactly, infant. Here, issue. The issue here is whether the form Mary signed is really an enforceable contract against her. If Mary is a grade 5 student, her age is implied to be less than 19 when the contract was made. Right? Sometimes you see grade 5, you see the age, you see pretty much kick you into the direction which must be a child. So the law in that case, he would be an infant under BC law, according to the Infant Act. That's the act that you learned regarding infants. A contract made with an infant is unenforceable against the infant, but enforceable by the infant against the adult. Is it sufficient to just say she's an infant? No. In your answer, make sure you put it in the act. I don't know why I put the cat picture there. Gotcha? Nah. Application. In this case, a contract made by Surlam Elementary with Mary is unenforceable as Mary is an infant. What's the case that's similar to this? R.E. Collins. And in R.E. Collins, Simon was an infant, and therefore, the contract cannot be enforceable. To conclude, therefore, Mary is entitled to reclaim the $10. Does everyone see the kind of the flow from where you get the question and then you see, okay, what is this question related to? And then from there we have to lay out what the law is, and from the law we apply it to the case, and then we go into conclusion. All right? All good? Okay. All right. I think we should have a break time here so that you guys can relax a little bit. I also want to know, how do you guys feel so far? Good? Are we a little bit more prepared, feeling more confident for Thursday's midterm? All right.
Hey guys, I have some questions on the other end. It's accepted some cookies. So, yeah, you guys can I'll put it out.
All right. I also want to ask, what are some recommendations that you guys want me to improve? And I try to do this earlier on so that in the next couple bits, I'm not going to use as dry perhaps, or what are some things I can improve on?
Do you want us to write it down?
No. Okay, so the way the feedback works, it's the same event where you found information about this session. We have posted a link to a Google survey thingy, and then you can just go to the event page, find the link, click into it, and then fill out the form. That's all you need to do. And if you're interested in going into the raffle draw for the Starbucks card, at the very end, the very last question, we will ask for your email address, and that's how we contact you if you win, which I'm going to do right at the end of the session. So check your email too if you're here.
Thanks. Yes. Feel free to come up have a good evening. So glad everyone's here to see me. Oh, yeah. Similar to this case, Okay, so I'll be starting in 2 minutes. So settle down. Have to go wash or something. So right now. All right. All right. How's everyone doing? Huh? Are we all kind of ready to move on? Yeah? Good. I know very, very headers and feedback. Not loud enough. I need to be louder. Right? People at the back can't hear me. Tell me. Right? All right. So, okay. We're gonna move a little bit faster now that we kind of got the flow of it. So we're gonna jump into legality here. Right? Flip the page. All right. So, problem is, Tactical Sushi in Caslano hired Mr. Pirazzi as a sushi chef. I can't pronounce that. 2 years ago, Mr. Pirazzi was a new immigrant at the time, was happy to get his first job. Yay! An employment contract contained the following. In recognition of the necessity of protection of tactical sushi, the Red Sable will opt for a period of 5 years following the termination of his employment, enter into competition with tactical sushi in Canada. He may not make or distribute sushi unless for personal consumption. When you get a clause like that, you go, okay, well, what is that? Okay. Sounds like a non-competition clause to me. Mr. Ferranze got fed up with the sushi restaurant. I'm not using that fed up, but anyways, that is actually how it's worded on my exam. So, anyways, fed up with the sushi restaurant, and so he decided to leave Go and start his own sushi restaurant in downtown Vancouver. While he does not dispute that he is competing, he says the agreement is not binding. Is the non-competition clause binding? I don't know. Is it? So we have to look at a couple things. This one's going to be a little bit long, isn't it? On the exam, right fast. Right, so issue here is whether the non-competition clause signed by Mr. Ferranze is enforceable. Restrictive covenants, such as the non-competition clause, are prima facie void, and therefore unenforceable. You mentioned restrictive covenant. What is that? Okay. Well, restrictive covenant is enforceable only if an employer can show that it is reasonable and not against the public interest nor a proprietary interest. Proprietary interest is, if you remember, court will look at the time frame, geographical area, reason, and scope. You have to write that down in an answer? No. Will you get full points if you don't? No. Anyways, that's why we go into the application now. After we got the law, we go to the application. Well, in this case, the public interest is probably not jeopardized. We look at public interest, not jeopardized because Vancouver is a large area, plenty of sushi restaurants, lots of choice for consumers. Consumers wouldn't miss it, right? If Pack to Go is out of business, just get sushi somewhere else. Pack to Go Sushi may want to restrict Mr. Ferrante from operating a similar business since he has developed knowledge of the recipes and business practices that he could use to compete with them. This is why in such a case, it might be good to argue both sides. Have to look at it from one side and then from the other side. But when it comes to your decision, it could go into, okay, well, then we have to look at the time frame and the area, which seem too broad in this case. 5 years seems excessive, right? Canada is a super large area to restrict Mr. Ferrante from operating it. To prevent him from making and distributing sushi anywhere in Canada seems unduly restrictive. Right? What's the case that we learned on this? Phoenix restorations versus browning. Right? Again, the restrictions are too broad, and therefore, because at first glance, non-competition clauses or restrictive covenants are prima facie void, meaning at first glance it's void and unenforceable, and says it's too broad, then it's unenforceable. The conclusion is, it is likely that the court will refuse to enforce the clause, making it unbinding. Any questions on this? Do we see why the court may refuse to enforce the clause? Because when we look at a non-competition clause, initially it is void, but the courts have to consider whether it would protect the public interest, whether it would protect the proprietary interest, and whether if it's broad in time frame or geographical area. And we notice here is too broad. Something that wouldn't be too broad, maybe 2 years, maybe in the Vancouver area, maybe in the Caslano area. I really don't see how Mr. Ferrante working in Toronto can affect their business at all, because what is Pack to Go gotta lose, right? It's a little business in Caslano.
Question.
Oh yes.
So how can you draw the line between 2 years and 5 years, or
Right. Okay. Right. So when this is when it becomes arguable. So when you say when the question tells you 2 years in the Caslano area, and you think about it, you would say, okay, well, that's probably not too broad. If it is, it would be much longer, and they would be much more obvious. Canada is a large area. North America, if they go so specific into the details that it's Caslano and just, like 10 kilometers away from this area for maybe 2 years, that would be something that's not too broad. Whereas they might tell you, okay, well, the recipe is super important because everyone working in the business can immediately know that the sushi requires, 20% of salmon and 30% of rice and 40% of something else. If they go really specific into that, it might be an indicator that, okay, well, something's important. It's important here, and perhaps the court would say the business must be protected. Does that answer your question?
Yes.
Normally, in that case, when you're answering a question, just make sure to to argue it, to reason it. Again, I would say the conclusion is not what matters most. In that sort of scenario, the answer might be is arguable. It could go either way. All right, misrepresentation. Finally, I get to see my little princess here. Alibaba. Well, I don't know. Does that have any relationship with Alibaba? Other than a name? No. Okay. Alibaba is a recent high school graduate who owns an Xbox 360 gaming console. Who plays games, but he used to play his Xbox 360 games for many years. After extensive use, console can now only play a game disc for 1 hour before the screen would freeze. Ugh. Alex isn't sure which component of the Xbox is causing the issue. You might know, but he doesn't. And he suspects it would be very costly to fix this problem. So this year, Ali decided that since he's going to university, he could sell his Xbox. Ali thinks, okay, well, he should not reveal the screen freezing problem because it's going to devalue it. Simply, he's going to advertise it for sale at $60. Nobody's going to ask me about this, right? Any purchaser will not make too many inquiries. What would you advise him to do in these circumstances? Alright, so the issue in this case is really whether Alibaba should disclose the screen freeze problem as a vendor. Notice that's an issue, then we go into the law principle. When a vendor must disclose latent material defects, latent meaning not easily visible from inspection, must disclose latent material defects of which he is aware. Okay. But when they're failing to disclose a latent defect, may be liable for fraud. Fraud is fraudulent misrepresentation. Either way, it's the same thing. So don't get confused there. Fraudulent misrepresentation occurs when one party makes a statement, right, a false statement, that induces the other party into the contract with the intent to deceive and the knowledge that it is false. A little review here. If you have knowledge that it is false, fraudulent misrepresentation. If you're not sure, but you said it doesn't have any problems, that's negligent misrepresentation. If you absolutely don't know at all, and then you have some paper or something that says, okay, well, it shouldn't have any problem, and then it did, that's innocent. Here, it's pure fraudulent misrepresentation. So when we apply it in this case, Alibaba may be liable for fraud or fraudulent misrepresentation if he does not disclose the screen freezing problem. What's the case related to that? Whitman versus Brinkman, where defect can be easily detectable at inspection. Here, with an Xbox, unless you inspect it for an hour like playing the game, there's really no way to get the problem. Right? Can't see it from like a simple inspection. So therefore, I would recommend Alibaba to disclose this defect. How do you feel about this question? Okay? All right? Okay. Undue influence, duress, and unconscionability. That's the next topic that we're going to cover. This topic will be a little bit more on memorization and understanding. I'm not sure how they can give you a case question other than I know we went through both Buckle Western versus Cigar, where input. So I decided to say, okay, well, what are the 3 criteria courts will use to determine if a contract is unconscionable? Give an example of an unconscionable contract that the court will set aside. And second question I'm trying to name 3 situations where there is a presumption of undue influence. What is a recommendation you would make to your client if undue influence is presumed? Do we have that? All right, go down. Okay. And answer this type of question, you really don't have to go about the issue with the law because it's not a case. You don't have to apply anything, right? So all you have to do is answer it kind of more like point form. It will be the type of question that you want to write. Like you can write pretty fast, right? 3 criteria must be shown. The bargaining positions of the parties were equal. One party dominates and took advantage of the other party, and the consideration involved was grossly unfair. Possible example of that, trying to persuade an educated elderly to sell their home for 30% of their actual value. Trying to trick the old lady. I wonder if I'm the old lady one old man one day. I would never be an old lady ox. Anyways, would I be cheated on this? I don't know. 3 possible situations where there's a presumption of undue influence. You can write any of the 3, 4 I put down. It could be more doctor and patients, lawyers and clients, financial advisors and clients, principal and agent. When one person, one party has a higher status, they're being influenced by that status. The question is, again, if undue influence is presumed, what would you recommend your client to do? You should recommend your client to seek independent advice. Do you kind of understand independent advice, right? Seeking independent advice is going to perhaps a different lawyer, different doctor, for example, so that you're not influenced. Okay. Everyone have any questions on the last example that we did? No? Alright. Back to these case problems. Somehow I like these, but I feel like you don't like it on the exam, but we're just going to have to work through it. Alicia Miller was hired for a cashier position at the corner bookstore. The bookstore's manager, Christine Lafayette, now French, corner bookstore, thought Alicia was a perfect candidate for the job, verbally offered her a salary of $25,000, a profit-sharing bonus of 2%, as well as a health care benefit of $3,000 reimbursable at the end of each year. Good package, right? I don't think I'm getting this. Okay, well, Christine told the HR manager to prepare a contract for Alicia to sign, but forgot to tell the HR manager about the supplementary health care benefits she offered. As Alicia, delighted to receive her job offer. Yeah, I'm so happy I got my job. Rapidly skimmed through the contract, signed. Done deal, right? Again. The benefit was nowhere mentioned in the contract. 1 month later, Christine left the corner bookstore. At the end of the year, Alicia, all her little receipts and drugs and prescription, brought it in to the accountant, and the accountant refused to reimburse her for the healthcare expenses. And Alicia bring a claim against the corner bookstore. What do you guys think? Right? When you think about that, this question you see, okay, well, an oral term, not in the written contract. You think about it. Parole evidence rule. Right? So going to the issue here, the issue here is whether if Alicia can rely on the oral term offered by Christine, that was the manager, in spite of the parole evidence rule. Once you mention parole evidence rule, click, define it. Parole evidence rule says that the court will not admit evidence of a prior oral term that S2 varies, alters, or contradicts a final written agreement. In this case, Alicia alleges that there is a benefit package not included in the terms of the contract. This is an excluded term that would add to the original written contract, and the parole evidence rule will operate to exclude that evidence. Are you allowed to bring an oral term that's not in the contract in later? No. Too bad. You sign what you sign, but didn't see it, too bad. Conclusion? Well, therefore, Alicia would likely be unsuccessful in a claim against the Corner Brook Sword. Yes? So don't worry too much about writing them down. What I want you to do is understand how we came about this answer. Right? Parole evidence rule. When we think about an oral term, that's the word that should click. After you get that word, define that word. Right? It's a prior oral term when the contract is already in place that admits evidence that adds to, varies, alters, or contradicts a final written agreement. Any questions on this? Make sure to tell me if you don't understand, so I can go through the logical flow. So you can feel a little bit more prepared when you see another question like this. All right? All good? Okay. Discharge of the contract. We'll move pretty fast here. Discharge. Right. I like this picture. I think I understand your frustration while I was making this. Looks like my head. Not me. On April 1st, 2015, terminal lawn sprinkling, PLS, entered into a contract with the Strata Council of the Mandarin Walk. I didn't know this was actually a Strata Council, but it is, apparently. A residential complex located in Richmond, BC. PLS will be responsible for sprinkling the lawn during the summer months, from July to September, and will be paid $3,000 in total. It is now July 2015. Ooh, 3 months passed. Okay. After a contract made, 3 months passed. This actually happened here, right? If you're here, you know. Stage 3 water restriction was implemented in Richmond, BC. The restriction prohibits water use for lawn sprinkling. I remember to write something once. Didn't have midterms back then. Anyways, assess the legal rights of TLS if the Strata Council of the Mandarin Walk sued TLS for damages in July 2015. Right. So in this question, how do we go about it? You think about a water restriction. You think about government imposing something when a contract is already made. Right? You think about, okay, well, something happened when the contract was formed. Something that came in that obviously, if you can't scrape the lawn, then how are you going to finish So here we look at frustration. Whether the water restriction enforced by the government qualifies as frustration. The law is that when we talk about frustration, we have to define it. Frustration is a supervening event beyond the control of either party that renders performance impossible or radically different, which cannot be self-induced. A couple things you have to mention here, right? Beyond the control, supervening event, something that happens after the contract, supervening event, renders performance impossible. Can't be just harder, can't be just more expensive, but impossible to do. Hardship is not frustration. Right? So in this case, the contract formed in April 2015, and the water restriction is a supervening event that would make the performance by TLS impossible. Immediately click to, what's that case? It's Turley versus Loud, where performance was not impossible in that case, but just more expensive. Here, there's no way to do it. You cannot be illegally doing it since the government imposed a restriction. Therefore, we can conclude that the TLS can claim frustration of contract to discharge its obligations, and that the loss will be apportioned equitably. Do we kind of see how we reached that conclusion? Right? How we went about, first of all, saying, okay, well, there's something that government imposed, the contract was already formed. This event came in, happened, now TLS can't perform the contract. What is frustration? Talk about frustration, define it, apply it in this case. And from there, make a conclusion. Right? You can claim frustration on contract. Would it need to pay everything? No. Or would it need to pay equitable loss or a portion of the loss? Probably. Does everyone have a question to that one? No? All good? Any problems here? No? Understand? Alright. We're going into the breach of contract and damages. This is probably one of the last major parts I'm going to go through. It's a very similar case, actually. The first part is entirely the same. On April 1st, TLS entered into the contract with Mandarin Law. But now I'm going back in time for a month. Right? In June, not July, June, TLS had a financing issue this time. Their employees went on a strike after TLS failed to pay wages. Labor negotiations are expected to extend into August. The Strata Council of the Mandarin Walk became aware in June that they have a strike. TLS is not going to perform my contract. What should I do? Gotta hire someone else, right? Can't leave my lawns not sprinkled, so they hire full cost sprinkling, which charges $5,000 due to delay notice. So right off the bat, $2,000 more for a new company to come in and, oh well. Question is, can the Strata Council of the Mandarin Walk sue for damages at this time? And can TLS seek protection under the doctrine of frustration? Kind of going back for when we sue for damages, here it's probably breach of contract. But when doctrine of frustration, that's going back a little bit and looking at discharge of contract. Normally, these type of questions would be asked together if you get a question like this on the exam. Let me look at part one first. can the Strata Council off the Magna Walk sue for damages at this time? Well, okay. The issue here is whether the Strata Council of the Magna Walk can sue TLS for anticipatory breach of contract. You might be asking, okay, well, how do we go about thinking that's anticipatory breach of contract? Okay, well, they had a contract in place, and then in June, TLS has actions that pretty much indicated that there's no way that they're going to have the job done, right? You know, they have a labor strike. It doesn't seem like they're going to perform the job. Mandarin Walk knew about it, became aware of it. That's why they had to hire someone else. Right? So you think, okay, well, since Mandarin Walk was notified, they can probably sue for anticipatory breach of contract. Since it's not July yet, the performance is not at the time of performance yet, so therefore, only anticipatory breach of contract. We anticipate that they're not going to perform their job. The law is that anticipatory breach, when we mention that word, we have to talk about it, occurs when one party explicitly notifies the other party in advance that it will not perform its obligations or by acting in a way that makes performance impossible to perform. Here, the Mandarin Walk was notified. They became aware that really it was impossible to perform. So in the application part, in this case, the fact that the labor negotiations would extend into August is an indication that the TLS will not perform its obligations. Is that arguable? Sure, I think it can be. Why? Because perhaps, maybe, the TLS can hire temporary workers. Maybe they're not limited to only hiring the unionized laborers. Perhaps they will get money in July, who knows? So it's arguable in the sense that if you strongly believe that TLS can perform, and it's too early to sue for anticipatory breach, then mention it in your application. But it is perhaps a little bit more obvious that they're not going to perform this, and since they will not be able to perform this due to the strike, then the matter can sue for damages. Okay. Did everyone understand the first part of this question? Any questions? Good. All right. Part two. A little bit backwards to frustration again. This is why I commented in the break is that I want you to think about the what if. A lot of times we see a case, there might be the potential that you can ask, oh, what if this happens? And it's a different scenario. So here, it might be something that they're going to add into the question that's going to lead you somewhere else this time. And here, can TLS be protected under doctrine of frustration? So the issue is, again, whether TLS can seek protection under the doctrine of frustration. We look at the law, right? Just like last time, when you mention frustration, make sure to put it in your answer. Frustration is a supervening event beyond the control of either party that renders performance impossible or radically different, which cannot be self-induced. Hardship is not frustration. When we apply it, well, in this case, the failure to pay wages leading to the labor strike is not frustration, because performance is just more expensive and difficult for TLS. right now, all TLS have to do is I will pay you. I will get money from somewhere else. I will borrow a debt, or I will try to find everything. Finance people know this. But they will try to get money, right? All they have to do is use the money, pay it off. There you have a labor force. Therefore, you can get the job done. Hardship is not frustration. What is frustration is something that's impossible, like the water restriction case that we just saw earlier. Therefore, we can reach the conclusion that TLS would be unsuccessful in claiming frustration. So, we're going to look at the other miscellaneous topics as we went through all of the kind of like the case questions. But I would like to say that these are equally important, especially I think ADR and interpretation might be something that you can look into because they tend to be tested sometimes. The ADR, I mean, the court systems and procedures is kind of all memorization, knowing how the flow, the structure, going through the court system, or what's a small claims court, what is the Supreme Court, what is the Supreme Court of Canada, um, looking at the sources of law, we're looking at common law versus civil law, we're looking at where we even come on cases, right? And ADR is something that they can memorize a little bit. Right? What's mediation? What's arbitration? What's the difference between these two? Right? Perhaps why we use ADR? Maybe just kind of yell out why. Anyone want to? No. Yeah.
Flexible.
Flexible. Yeah. Speed. Yeah. Less money, less expensive. Yeah.
Save relationships.
Save relationships. Yeah. True. Oh, yeah, yeah. You can choose her. Yeah. So, any more? No. So all of these are like perfect examples of why to use ADR. Know it, memorize it. And the last part that I want to walk through is interpretation. Right? Interpretation. There's kind of a little timeline that we go through. The first thing that we look at is literal term. Right? Is it clear and unambiguous? If it's clear, then we have to look into the second, right? The liberal meaning. So literal, liberal. A liberal is what a reasonable person standing from the outside, right, interpret it in a liberal way. Finally, the last one, contra proferentum. Contra proferentum. Remember this word. Do you remember this word? Okay. So contra proferentum is what? Anyone know? That's
Judge rules against the person who created the contract or the one who's supposed to go about putting together the contract.
right. Perfect. So glad that you guys know this. Okay. Before I jump into the final advice, I think we should go over the cases, just in case that you guys don't remember which one is which one. Yes, go over maybe a one-sentence introduction into each case that you learned so far. Does that sound good? Yeah? Okay. Well, first case we looked at was Libman versus Canada. Finland versus Canada was about the charter. Does the charter apply? Were rights infringed? And the third criteria is the infringement justifiable under Section 1 of the charter? Okay, we looked at Rudder versus Microsoft. You're bound by what you sign. It's jurisdiction clauses as set out in the contract, in the contractual term. We looked at R versus 27970 Alberta on false advertising. 27970 Alberta is actually British Canada, as you know. False advertising on the Competition Act. Montaigne versus Schroeder. The question was on whether it was a counteroffer or an inquiry. And do not want to repudiate if a counteroffer was made by mistake. In consideration, we looked at Caligari versus Milo. That was the consideration. And that consideration could flow to a third party. Am I going at the okay pace? Yeah? You're getting them down okay? Yeah. Tulsa heaters versus Secrude. We talked about this when we talked about estoppel. Right? I had a question earlier on. What was doctrine of promissory estoppel? Remember, estoppel is the same thing as equitable estoppel, same thing as promissory estoppel. There's no difference in that. When we think about estoppel, what's the case? Tulsa heaters versus Secrude. What's the other one that we talked about? Duke's cookies versus ABCAMS. Interpretation. We looked at DK holdings. We look at the true intent of the party, not the words, not just the words. Right there, we have to look at the liberal, because DK pretty much the top value lost pretty much all their profits. Black Swan versus Gold Belt. There's no need to look at the surrounding circumstances because the terms of the contract was unambiguous. All you have to do is look at the literal meaning using the literal approach and Black Swan. Capacity. That was the case of RE Collins. And we look at the incident. An act not enforceable to the minor, but is enforceable against the adult. Court can give an infant binding capacity. I hope this is helpful so that you don't have to read over your cases again. Okay? If you just kind of write it down. Most of the time you don't need to know specifically what happens in the case, but do know what the case talks about and when to apply it. So next one, Cirilli versus Lamb. It wasn't a case of frustration. Left it open when the sale of their property didn't occur, and it could have been in a condition. Basically, it wasn't a case of frustration because the necessity to sell the property doesn't make more sense. Yes? So early work plan. Everyone get that? Yeah? People at the back hear me? Okay? Okay. West Coast versus Colin. Similar case to Baxendale versus Headley. Headley versus Baxendale. Breach of contract. Case on breach of contract. I'm not necessarily following the order. notice this. But this is in the breach of contract section, you find it. Blackcomb versus Schneider. That was the case on liquidated damages. Again, a breach of contract and within industry standards. For parole evidence rule, we looked at General Tire Canada versus Elworth. It was an oral collateral contract, incompatible. Parole evidence rule, don't rely on anything outside of the written agreement. Collins versus Dodge City was the case on misrepresentation. If I could buy an air conditioner in that car, was told there is in there, didn't get it, misrepresentation and duped her into the contract. Winsman versus Brinkman. There was no fraudulent misrepresentation because the water leak problem can be easily inspected upon inspection. Chose not to do it, that's your problem. Alright, so, Buckle Western versus Cigar. Now, case on undue influence and duress. There was no pressure, and it was freely exercised for the benefit of their family business. Got that? Okay. Legality. Maximus versus Kostek. The object must be legal in a contract policy. Legality. The other one is Phonics Restorations versus Brownlee. That was the criteria for a reasonable non-competition clause or a restrictive covenant. Again, looking at legality. That was on post-employment restraints and non-solicitation to clients. Basically, again, that one was too broad and doesn't work. Other than these cases, we talked about Carlisle versus Carbolic Smoke Ball Company. It's not a case that you should worry about too much, but that one was on intent. Okay. It was an intent to make an offer, and when the purchaser of the smoke ball got sick, sued, won the case. All right. Final piece of advice. I'm pretty sure you read this by now, but 4 things. Conclusion is not what matters most. People think I can just answer it. You would not believe how many people just write a one-word answer saying yes, no, something like you can sue. But what is really, really important is you apply the correct law principles and remember how to define it. When you talk about frustration, define frustration. When you talk about pro-evidence rule, define pro-evidence rule. Write fast and check on the time. Each of the case questions is going to tell you this one's for something like 5 marks for 7 minutes or 10 marks for 15 minutes. Make sure write fast. And if you run out of time, make sure to just put it in point form and put whatever you can. Right? So if you do have time, make sure to write as much as you can, more inclusive the better. Practice answering more problems. Sure, either Professor Barbara Cox or Professor Alan McIntosh must have given you some practice problems to go through. They're very useful. Don't stress. Either rest well. It's not that hard of an exam. Yes, question?
With the questions, you know how you display them? Each case was specific to a certain law. Well, case have more than one?
Right. Good question.
More than one terminology that we should use?
The way that I put it is separated by topics, so you can match and remember them better. On the exam, they're not going to tell you separate topics. They're going to kind of combine it all into one. For example, discharge and breach of contract may be in the same question, right? Might not necessarily be all that separate.
But they're going to ask for all the.
But they're going to ask you on a lot of
So for those questions that have more than one term, yeah, if we just state one, we're going to lose marks because we're not stating
right.
I'm almost done. Just 1 sec. Right. Okay. Well,
Thank you guys so much for attending. I had an enjoyable time up here. Good luck on your exam. I know you will do well.
okay. So the email has been already sent to the winner of this raffle draw. So if you go to the same email that you put on the form, you should be able to know whether or not. So if you win, please come up over here and show me your message.
Okay, so I'm going to be here for another 20 to 30 minutes or so. So if you do have questions, feel free to come up